Hey everyone, welcome back to the YouTube channel. It's your host, Stephen Hughes, the Harsher Real Estate Pro. Today, I do have a special guest. It's first time for the channel. I actually do have an attorney, and I know we're going to talk a little bit about preventing probate. If you've been on the channel, you've probably seen I've talked a little bit about that. Of course, you see I talk about some other issues and concerns and benefits and services to seniors, but we're going to go ahead and have our guests introduce themselves and tell us a little bit about what they do in the practice of law. If you want to go ahead, that'd be great.
Perfect. Well, thanks, Stephen. I appreciate the introduction and happy to be here and have a chance to visit with you and the channel and hopefully be able to answer some basic questions about probate and estate planning as a whole. My name, again, Matt Miles. I'm an attorney at Floor and Miles in Ogden, Utah. I've been practicing for coming up on 7 years. I joined the firm after graduating from the University of Utah Law School. I grew up in Ogden and I practice with my dad here at Ogden now, who is also an estate planning attorney and does estate settlement like myself. I joined him and his experience and the other attorneys here. Love the Ogden, Weber County area and enjoyed practicing here. But happy to answer some questions. Talk today a little bit about probate avoidance. Lots of people have heard about probate and it can be intimidating and it can be a long and drawn out process. So if possible, it's a great thing to avoid for your loved ones.
It's kind of funny within my side of things, there's a big push within the real estate space to kind of get into probate. And it's one of a couple ways I got into working with seniors. And I think, of course, I know some of the common misconceptions like, oh, if I have a will, I won't go through probate. No, you will still go through probate. So maybe we talk about what exactly does probate mean? So the really basic stuff. And, how do we prevent that probate process and why should they prevent it?
Sure. Those are two great questions. Let's start there. Before I jump into it, let me just be clear that this isn't legal advice. This is my disclaimer at the beginning. This isn't legal advice. I'm talking in general terms. And obviously, I'm only licensed to practice in Utah. So if you're outside of Utah, you may need to even find further advice, but seek advice from your own attorney. This will hopefully give you some basic information as you're doing some research on these different topics. So, first of all, what is probate? As I like to describe it, probate is the process of having someone appointed by the court to settle a deceased individual's estate. So you lose a loved one, your mom or dad pass away, and somebody needs to be appointed to be able to access bank accounts, to be able to deal with retirement, to sell a home, whatever those different things may be. Probate is the actual legal process of appearing in front of a judge, sending out appropriate notice, and getting appointed or having someone appointed as it's referred to in the state of Utah, a personal representative, also known as an executor or an administrator, but in Utah it's referred to as a personal representative, so that you have the authority to execute documents on behalf of your deceased loved one. Probate can be a long process, but ultimately the goal is to get somebody appointed to handle those things. So the idea is, how can we avoid having to go to court and pay the attorney's fees and deal with sending out notice to family members and the lengthy time process? Typically, when you file for probate to get somebody appointed, it could take anywhere from 6 weeks to 6 months to get somebody appointed. And that's a long time when we're talking about a house that's sitting or bank accounts that's sitting. Again, if we can avoid that, it's a great thing to avoid. Briefly, before we talk about how to avoid it, let's talk about when probate is necessary. Stephen, you mentioned that people have this idea that if I have a will, I don't have to go through probate. That's not necessarily the case. Sometimes it is. And so I want to clarify how that works. So currently in the state of Utah, if your estate is worth, your estate being the assets that you own at your death, if your estate is worth more than $100,000, or the kicker here, or if you own real property. And most of the time, as it relates to you, Stephen, and real estate, it's because there is real property, right? So if you die owning real property, whether it's a lot that's worth $5,000 or a house that's worth $1 million, that estate, your estate is going to have to be probated because somebody has to be appointed to be able to sign the real estate documents to sell that piece of property. The two ways you end up in probate, whether you have a will or do not have a will, is if your estate's worth more than $100,000 or you own real property, a house, a cabin, land, something of that nature. Now, that process of probate can be avoided entirely if that piece of property or if your assets are not owned in your name when you die, but instead are owned in a trust. So the most common way to avoid probate is to take your assets, like your house, and have them be held in a trust, of which, typically speaking, you will be the owner of that trust and the controller of that trust. The terms we use in the trust world is you're the grantor, the person who created the trust, and you're also the trustee, the individual who's in charge of your trust. So we would set up a trust in which you own the assets, you control the assets, you do with them with what you want while you're alive. The kicker is, or the real benefit is that trust law allow you to name somebody as your successor to take over automatically when you die. And that happens by virtue of a death certificate, and it happens automatically without having to have a court order. So just that alone, by having your home owned in a trust and your other assets owned in a trust, you've now just saved your loved ones and family, 6 weeks to 6 months of a headache and, the court filing fees, the attorney's fees. And the cost is different everywhere, 1,000, 5,000, depending on who and what and how litigious the probate is. But that headache can be avoided by placing your assets in a trust. Now, we'll get into this, I'm sure, a little bit later, but then your trust should direct your trustee as to how you want those assets, the home, the cash, to be distributed.
Yeah, there's a couple things with that you bring up. You mentioned the $100,000 mark or real property. It's funny. I wanted clarification on this. I think it's called the small estate affidavit or something if they have less than 100,000 or no real property. Because I had a mobile home, I think 2 years ago. She had passed away, and the nephew from Colorado basically sold the home to us for like $5,000 because it was totally trashed, and she had passed in the home, and he only had to do that, and she had a will. There's a big misconception about wills that you need to not be poor or you need to own a bunch of stuff. I think even if you are making minimum wage and you're renting and such, you still want to have a will. I think every adult should have a will. I'm curious if you had a comment on that before I ask another question.
Sure, yeah, I'd be happy to address that. You're exactly right. I mean, there's a lot of benefits outside of avoiding probate that a trust accomplish. But even if you're under that $100,000, and you're correct, you referenced the Utah Small State Affidavit, which allows somebody to sign on behalf of a deceased individual if the estate is under $100,000. And that's what I believe you're referring to, is the nephew was able to use that small state affidavit to liquidate the mobile home. The idea there is, though, he then takes responsibility when he signs the small state affidavit. He takes on the liability and the responsibility to then distribute the funds where they're supposed to go, either in accordance with a will, if there was one, or in accordance with the laws of intestacy. And let's talk about that, because that's what plays to what I think you're referring to. In the state of Utah, if you die without a will or a trust or beneficiary designations, that's another way that assets can pass. You can set up beneficiary designations on a retirement or bank accounts or life insurance, and they will go directly to those beneficiaries. But if you own assets that don't have a beneficiary designation and you don't have a will, then the Utah laws of intestacy are going to direct where your assets go. That may be where you want them to go. As a society, we have voted on laws to say, hey, this is where we think people would want their money to go or their estate to pass if they did not have a will. But that's kind of like a one size fit all, and we're doing our best to try to accomplish that. That may not be the case for you, Stephen. That may not be the case for me, or that may not be the case for someone who is listening to this. So it does its best, but if you want to make sure your estate and whatever assets you own when you die go to the correct people, you ought to have a will. You ought to have a trust. You ought to have some type of estate planning document that directs where your assets go when you die. So then it's your choice, not the state laws that are controlling where your assets go. So you're exactly right. Once you're an adult, once you own assets, you ought to have some type of estate planning document to direct where your assets go when you die. The other big benefit of a will, for, as you indicated, once you're an adult, once you have children, your will is where you nominate a guardian to raise your children if something happened to you. It's a major decision. That's a huge impact on your children's life if something happens to you. That's where you get to put in a legal document, if me and my wife pass away, or you and the mother of your children pass away, this is who we want to raise our children. There's really not a more important decision out there than to who's going to be the guardian and raise your children. So once you have kids, once you have assets, a will is a very important thing to say, this is where we want the money to go, and this is who we want to raise our children. My dad, as I indicated, I practiced with my dad, Kelly Miles, and he's been doing this for 30 plus years. He told all of his kids, once you have a child or once you buy real property, a house, those are the two big reasons why he directs his kids. Hey, you should have a will and a trust in place. The will to nominate a guardian, right, who's going to raise the kids, and the trust to secure and protect that property to avoid probate. So I hope that answers your question on should people get a will? Yes, they should. Even if they rent, even if they don't own real property, even if they're under the $100,000, they still should have a will so that it's their choice. The other big decision that gets made in the will is who's going to be in charge. The Utah laws have a list of priority over who would be in charge of your estate if you died, but that's not your choice. Again, that's the cookie cutter. That's us as a society trying to figure out who we think would be the best person, but it may not be perfect for your situation. And the only person who knows your situation is you. So you ought to be the one to say, hey, yes, I'm married, or yes, I have kids. And generally speaking, those are the people that have priority. But maybe it's your brother, maybe it's your uncle, maybe it's a trusted friend that would do a really good job and you would trust them to take care of things. Well, then you need to put that in writing so that your wishes can be honored and the court can know that to put that person in charge.
Yeah, it's interesting. There's a couple things you mentioned there. I mean, the kids is something I don't even think I would have asked that, but it's such a great point because my wife and I have that to where if both of us were to unfortunately pass away, my daughter would actually be raised by my sister. So
Sure.
we had to line that out because there's family dynamics. I think every family has that to where you want to make sure that there's a plan for your offspring. It's just that's a really great point that I'm glad you brought up that even personally, I've had to make that decision, and any parent should, really, really should. This is a question because you mentioned life insurance, and life insurance is considered an asset because it's going to pay out. I've heard of instances where people did have a trust set up, say for the house and other things, but then some big insurance policy or other financial assets were not included in that trust, and the family was still forced to go through probate because those assets were not named. Is that something that can happen? Is that a concern when you set up a trust to make sure some of these other assets are named within that trust, or should it be a separate document? I really don't know.
Lots of different assets can create problems that although you have a trust, you still end up in probate due to these other assets. So let me just give you some basic information about how a trust operates. A trust can only control assets that it owns. What I mean by that, the example that I like to use because it paints a clear picture is I can't create a trust for me, Matt Miles. I can't create the Matt Miles trust and say in my trust when I die, Stephen's house is going to go to my kids. How would that make sense? My trust doesn't own your house. You own your house. You know, it's going to go according to whatever you choose to do with it. So the trust itself has to own the asset to be able to control it. And that's very clear. And people understand that as it relates to real property like a house. But the same thing applies to bank accounts, to life insurance, to retirement, to water rights, to companies that you own, all these different types of assets in your life. They have to be owned by the trust in order to be controlled by the trust. When you set up a trust, just as important as creating the trust and having it worded correctly and it being a valid document and hiring someone that knows what they're doing, is also taking the time to appropriately fund your trust. Funding a trust is the process of making sure all those assets get transferred into your trust now, or they get funneled into the trust when you die. And life insurance is the example that you brought up. The life insurance would not be owned by the trust right now. It would be Stephen's life insurance policy that you're paying the premium on, and you would name your trust, the Stephen Trust, as the beneficiary of your life insurance, so that if something happened to you, all the money would go into the trust and it would follow the terms that you had set up. Let me give you an example. Stephen, you have minor children, correct? Some that are
Oh,
still
yes.
minors.
Mhm.
And you may say in your trust, the money is to be held in trust for our minor children to be used for certain things, like education, like their medical expenses, certain things that are beneficial. And then when they reach a certain age, they may receive their inheritance. So the trust would receive those funds from the life insurance company. and be used according to the terms of the trust, and then eventually distributed according to the terms of the trust. So, yes, if there are assets that got left out of the trust because there was no beneficiary on that life insurance, then an individual may have to probate the estate in order to get that money to the appropriate people.
I had a very interesting conversation. I think it was yesterday, 2 days ago. Went to a senior networking meeting down in Salt Lake.
Right.
And I had mentioned I've really been on one about other senior professionals asking their clients if they have a will, because only a third of Americans have a will. I mean, it's
Sure.
shocking how many people don't. And, this person came up to me and said, "Oh, yeah, you do that. We have this service where people pay $95 to get a will and a trust set up, blah, blah, blah." And I know just from working with people, there's going to be mistakes because they don't practice law every day. In this, what you defined with the life insurance and all, I guarantee knowing the types of, people I've dealt with and just people in general, they're probably gonna overlook that. And
Sure.
they still end up having this problem where they still end up having to retain the services of an attorney. So what I want to kind of say here, and you can comment on it if you'd like, is if you're going to do any sort of estate planning, you really do need to talk to a real life person face to face. And I think that's one of the things that impresses me about you because you will still meet people in person. And, you just don't funnel them through some other like an assistant or a junior attorney. They're meeting with you directly. It's just
Sure.
really not as common to find as some people would think. But I would encourage anyone watching this, of course, to, go to you for services. But again, there's just some people that will, sell you that flat fee service. But if you've ever heard the saying, if it sounds too good to be true, well, it probably isn't true or whatever. It's said a lot of different ways. In my opinion, with legal matters, that's pretty accurate.
Well, sure. I get the question, and I'm not afraid to address the question. But I get the question: why should we hire you to do this when I can go to LegalZoom or have ChatGPT draft me a will or a trust or different things like that? And sure, you can. Obviously, I can't stop you from doing that, and I'm sure there's a number of people who do that. And a lot of times, I'm grateful for those people because there ends up being problems, and I get to do legal work on the back end and generally make more money on it in the long run. But I'm obviously being kind of joking there. But the biggest thing is when you create a will or a trust, if you don't know what needs to be included or you don't know the questions to ask, are you going to catch everything? And that's the idea. I mean, if you know how to fix your toilet, you don't hire a plumber. If you know how to fix your car, you don't hire a mechanic. I don't know how to do either of those things, so I hire people to do those things. If you don't know how to draft a trust or a will, you hire somebody to do it, and I'd be happy to do that. There are a number of people who try to make it work, and sometimes I believe it works just fine, and sometimes there are problems. I will tell you, you hit the nail right on the head. The most common mistake for people who that create a trust online, where I get kids who bring in a document and say, "Hey, my mom or dad passed away and I need to settle their estate. They had a trust." It's very clear when it wasn't drafted by an attorney based off the spacing and the structure of it and what it looks like. I could tell it was a form. The trust itself may operate just fine. There may not be any problems with the trust, but 9 times out of 10, all of the assets did not get placed in the trust because they did not have somebody. Do you own life insurance? Do you own a business? Do you own, a house? What bank accounts you have? And they're not getting the help they need to make sure all the assets are in their trust. And that is something that we prioritize here at Foreign Miles. My dad, again, been doing this for 30 years, and now me for the last 7, is when we create a trust, our package not only includes the drafting of the documents, but also the funding of the trust. I will prepare the deed for your home. I will help you direct your assets into the trust so that at the end of the day, when something happens to you, there's the best chance of it flowing through that trust, avoiding probate, and it going to the place that you want. A trust that doesn't own any assets is worth the piece of paper that it's written on because it's not controlling anything. It might give you some peace of mind, but it might not operate the way that you want. It might not control your assets, and your kids will be at probate anyway. So those are, that's one of the biggest reasons, whether it's me or somebody else that is a professional and can help you make sure all your assets end up in the trust. That's an important part of doing an estate plan. When we create an estate plan for you, it consists of four main documents. There's the trust itself, which, as I indicated, owns and controls assets. It designates who's in charge when you pass away, and it says how the assets are going to be used and distributed after your death. It's the main controlling document. then we still create a will for you. And if you've listened to anything that we've discussed today, a lot of times you don't want a will because a will has to be probated, but there still is a will. It's called a pour over will, and it directs any of your assets that got missed to be poured into the trust. The goal is to never use it because if we have to go through probate or use a small state affidavit. But it's better to have it and not need it than need it and not have it. So it's created. It's also the document that designates a guardian for your minor children, as we hit on. And then the third document is a general financial power of attorney. It's a legal document, as most people are familiar with, that allows people to transact on your behalf, manage your financial affairs if you needed help due to being sick, quarantined because of COVID, out of the country, something like that. And the fourth document is your Utah Advanced Healthcare Directive, who can talk to doctors and make medical decisions if you couldn't speak for yourself. And it also includes your living will or your right to die, at what point you want the plug to be pulled if you're being kept alive by machines. And then in addition to those four documents, as I just indicated, I help you with the process of funding your trust, transferring your assets into the trust so that we have the best chance of making sure your trust operates the way that you want without having to go through probate. I'd be happy to answer questions. I'm at Floor and Miles. You can reach out and you can find us online at floorandmiles.com. Leave us a message there or our contacts there. Be happy to talk with you, answer further questions. As Stephen also indicated, I do meet in person with my clients and I offer a free consult so we can sit down and talk about some of these things. Also, I do estate settlement, which is if one of your loved ones has passed away, I will handle the probate process or settling a trust, or if there is no will, it's still often a probate process, but we don't probate a will. So happy to answer any of those questions and get involved there. Thanks, Stephen. I know we're trying to wrap this up, not go too long. Appreciate you having me on and giving me a chance to talk about some of these things. I believe there's a lot of value in it, not only for the individual who creates an estate plan, because it gives you peace of mind, but it also helps your kids. It's a wonderful gift to your kids so that they know, hey, things are in order, things are going to operate the way that we want. And so give me a call. I'd be happy to speak with you.
Awesome. Hey, you wrapped that up perfectly. Again, Matt's information will be in the description box below. Of course, if you have any questions or comments, you can reach out to him directly, post below. Please like, share, and subscribe. Of course, Matt and I are going to chat for a minute or two after the video is done. But until next time, thanks so much for being here.
Thanks again, Steve. Appreciate it.